Good afternoon, everyone, and welcome to this webcast. We're going to be talking about FERCCA today and taking your questions. My name is Mike Evans.
And I'm John Kogut.
And like I said, we're going to be talking about FERCCA today.
FERCCA is the Federal Erroneous Retirement Coverage Corrections Act. It's under Title II of Public Law 106-265, and it was enacted September 19th, 2000. And what it is generally, an individual must be in an incorrect retirement plan for at least 3 years of service after December 31st, 1986 to be potentially eligible for a FERCCA relief.
Yeah, and the history of how this all came about in general is essentially, in the beginning of time in 1920, actually, CSRS was the only retirement system that was in existence. So everything was pretty straightforward at that point. We then had Social Security come into play, and in 1984, federal employees became subject to mandatory Social Security. As a result of that, Congress had to create a new retirement system. They created FERS, and when FERS came into existence, now we had a situation where we had employees that could have been covered under CSRS, they could have been covered under CSRS Offset, they could have been covered under FERS. The driver for all of this was Social Security coverage. And so, of course, with multiple retirement systems, you have the potential for errors, which could be quite substantial and quite harmful to an employee if they were in the wrong retirement system. So essentially, FERCCA was created to make these employees whole if they were placed in a wrong retirement system for at least 3 years.
And so before we move into the questions, we're going to cover the main BALs, the reference guides you can use to correct FERCCA issues. The main one is BAL 04108, and that is making eligibility determinations under FERCCA. So there you'll find the FERCCA worksheet, the out-of-pocket expense guidelines, as well as information on where you send the FERCCA worksheet to OPM. Another one is the BAL 02103, which is correcting erroneous FERS coverage, and this is for errors that are less than 3 years. The other big one is BAL 05103, which is retirement coverage error corrections. This is a step-by-step guide covering corrections. So CSRS, they were incorrectly in CSRS, they belonged in FERS. It gives you a guideline of what to do if they elect FERS or CSRS Offset. And then finally, the last BAL is retirement coverage error corrections, and these are for errors that do not provide an election, and that's BAL 03104.
Yeah, and there are some errors that we see on a regular basis that are quite common for FERCCA. For example, one of the big ones that we always see is somebody who had passed the 5-year test, who was then, of course, going to be vested in the CSRS retirement system, and then they later acquired a term appointment. If any of you have been through FERCCA class before, you know that term appointments are excluded from CSRS by regulation, and so a lot of times what would happen is agencies were, particularly in the early days of FERS, because the term appointments were not excluded from FERS, automatically put somebody in FERS coverage, even though they passed the 5-year test. This created a problem because that was erroneous. An employee should be placed in Social Security only because they are actually vested in the CSRS retirement system and have to be able to elect out of that. If an agency automatically places someone in FERS when they pass the 5-year test, they're taking away the choice of the individual. And so that, in essence, depending on how long that error lasts, as Jonathan said, if it's less than 3 years, it's going to be what we call a deemed FERS election. If it's 3 years or more, it's going to fall under the purview of FERCCA. So that's one of the biggest errors. What's another one that we normally see on a regular basis?
I think it'd be generally CSRS. They belong in FERS.
Yeah, and that's a costly one. That one is actually, if you've been through our FERCCA class, that's the one that's the most expensive for agencies. When somebody's erroneously in CSRS, they should be in FERS, and they actually elect FERS. In cases like that, FERS actually costs the agency much more because they have to do all the automatic 1% for TSP. They have to do all the, lost earnings on that 1%. If the employee decides to do makeup contributions, the agency has to replace all the earnings that they would have earned on those makeup contributions, as well as any dollar for dollar matching on any of the other contributions that the employee would have contributed to. So that's a very expensive one. Those are pretty much the most common ones. If you want to, we're going to be taking questions, so you can email benefits@opm.gov, and we'll be more than happy to take your questions.
And one thing to add, aside to the BALs, there's also the handbook chapters, several chapters that cover, for example, Chapter 10 has the worksheets, so Social Security determination table, new hire, rehire, transfer and conversion, step-by-step guides for finding if someone has mandatory Social Security coverage or what system they should fall under.
Yeah, and Chapter 10 was recently updated. So this is, for those of you who are familiar with the CSRS and FERS Handbook, Chapter 10 is one of the chapters that is recently updated. It has all the new coverage chapters, or all the new coverage tables that include FERS RE and FERS FRE. And that's another thing that we probably should mention, is that if somebody is in FERS and they should be in FERS RE or FERS FRE or vice versa, that is not a FERCA error. They're still essentially FERS. It's just they're paying higher contributions. So again, remember, if somebody is erroneously in FERS RE, should be in FERS, or FERS FRE, should be in FERS, any combination of those are not FERCA errors. Those are just salary overpayments or underpayments and have to be corrected the same way you would treat any other salary or overpayment or underpayment. There's also Chapter 100, reemployed annuitants. That one's recently updated.
Chapter 12 has other government systems. That could be helpful in FERCA issues, as well as the senior officials, Chapter 101.
Yes, senior officials are, particularly now we're seeing a lot of turnover with senior officials recently, and a lot of them are senior officials and reemployed annuitants. So I know I've gotten a lot of questions recently from agencies regarding that. So again, Chapter 100 is recently updated. Chapter 101, although it hasn't been updated recently, not a lot has changed with senior officials. I mean, the big thing is that they're subject to mandatory Social Security coverage right away when those Social Security amendments of 1984 went into effect. Another thing to be aware of with those senior officials is that they had lots of special elections back in the 1980s. And that could make you think that you have a FERCA error when you really don't, because those special elections gave them some options that wouldn't normally be available to an employee who wasn't a senior official. You're also going to see those weird kind of coverage errors when you're dealing with somebody who came from the legislative branch, because the legislative branch has some special rules.
With that, I think we can open it up to questions, and you can also email questions to benefits@opm.gov.
Do we have questions? Awesome.
Okay, the first question is, after reviewing several employee EOPFs, I've come across situations where there's an SF50 indicating that the employee made an election, but that there's no documentation showing the official election on file, neither the EOPF nor working file. Does this constitute a FERCA error, and if so, would this give the impacted employee an opportunity to make a new election?
Yes, that's possible. So what it sounds like they're referring to is the FERS election form. And without any type of documentation to show that the employee elected FERS, it sounds like it would be an error, and they were erroneously placed into the wrong retirement system.
Yeah, depending on the length of the error, when this actually happened, if they just recently onboarded with you, if it's less than 3 years, clearly it wouldn't be a FERCA, but if this happened some time ago, yeah, but at this point it would be a FERCA error. That's one of those things, you need something signed. You need a FERCA election form signed. I mean, the reality is if an employee challenges you and it goes to MSPB or wherever in their due process, you need to have some evidence to prove that they actually elected FERS. Otherwise, you're going to lose.
Yeah.
The next question is, can you break down what happens when the FERCCA correction involves multiple agencies?
Well, with multiple agencies, that's always an interesting one. For the acquiring agency, for the current agency, you have to correct all the 50s back to the date of the error. However, you're not going to be able to correct the payroll cards. You're going to have to take those 50s that are corrected that cover the period with another agency, and they're going to have to correct the they're going to have to correct the payroll cards for that period of time. And but of course, the current agency is the one who's going to do all the HR actions. I believe it's all detailed in
And it's
05.
05103, it does cover all the scenarios as well as if the error only occurred at one agency or multiple agencies. And then it also does depend on when how long the error lasted and what payroll has to do, whether it's barred or non-barred years. So it breaks that down as well.
Yeah, because remember, for FERCCA, whenever you're doing the corrections, for those of you who are listening who actually do the corrections, remember that you have to separate barred years from non-barred years. And just to clarify what that is, for those of you who've maybe never been through FERCCA training or this is your first experience with FERCCA, Social Security has a statute of limitations under which they can actually make corrections to the Social Security record. That is generally 3 years, 3 months, and 15 days. So from the beginning of the year. So essentially, you're looking at a statute of limitations for when they can make these corrections. FERCCA actually provided a way for us to correct Social Security record for the barred years, but it involves moving money from one trust fund to the other trust fund. In a situation that is not FERCCA, there's really no adjustments that can be made to the barred years. It gets very difficult to move money around. So that's one of the advantages of FERCCA, is that it actually provided a way for us to make employees whole for the barred years. But again, remember, you have to treat the barred years and the non-barred years separately whenever you're doing these corrections.
Okay, the next question is, why are we receiving cases 16 years after the employee retired when we do not have any records or knowledge as to how the retirement was calculated?
You wanna?
Well, basically, the way the law is designed is that it's the FERCCA has to be corrected at the last agency of the employee.
Yeah, and there's no statute of limitations on FERCCAs. There is no time limit for when a FERCCA error could be identified. So in some cases, we may have, the agency may have submitted a case before, even possibly before FERCCA came into existence. And there was a coverage error that will qualify now under FERCCA. And maybe we didn't even catch it until the person died, and now it's up to the survivors. That could be a reason why you're seeing these. It could be that there was some change that we had to do, or the person got reemployed. We see this a lot with reemployed annuitants, where they were, an employee retires, and again, this could have been pre-FERCCA, could be after FERCCA, but generally it's prior to FERCCA legislation. The person retired and now they're coming back to work. So again, just like I mentioned earlier with senior officials and reemployed annuitants, you're going to have to look at Chapter 100 to deal with reemployed annuitants. As I said, it's been updated. It's got the most recent information. And again, if you have any questions when you get into something that complex, you're going to want to reach out to your benefits officer first. If you are the benefits officer, you know who your liaison is at OPM. Reach out to us, and we'll be more than happy to help you.
The follow-up question to that is, if we're handling the case for retirees, can OPM forward the retiree's information in regards to the calculation for the annuity so we can explain the impact to the retiree? We do not know what service credit or sick leave was used in the annuity calculation. We would also need updated contact information and redeposit information for civilian and military service.
Yeah.
I think with that, we would be able to assist with giving updated contact information, especially if, in this example, the employee's been off your rolls for 16 years, you would most likely not have a current address. As well as I know we can give the current gross as well for the annuity.
Yeah, exactly. We can provide that. We can even provide service histories. However, in a situation like that, you're probably going to want to request the OPF as well, because you're going to want to go through and review all, because you're going to, of course, have to do corrected 50s as well. So you're going to need the OPF in order to do that. So you're probably going to need to request the OPF regardless.
As well as you want to do the FERCCA worksheet as well, because again, this will help you when you're counseling the employee to let them know, show them the service history and explain the error to them.
Yeah, because this, there are things that lurk in the service history that you're going to really have to go through, particularly if it's an error that was that long ago. You're probably going to want to double check everything. We have had instances where, for those of you who've heard of it before, Connor cases have popped up from time to time. And inevitably, I know we were both in processing, so we've seen cases where something has happened, and even if it's not a FERCCA, just in the routine process of going through something, we found errors that have occurred in processing earlier and had to go back and make adjustments. So, hopefully not, but occasionally you will find something that's an additional error other than a FERCCA along with the FERCCA error. So, yeah, the more official documentation you can have, like the OPF and whatnot, is going to assist you.
For these older retiree cases, why is the FERCCA service history worksheet required when OPM already has the information and we do not have the records? So we're making up the worksheet based on IRRs, and OPM is the one notifying us of the error.
Looking into that, I would say, you want to get the OPF. As well as in the counseling, you'll have the service history worksheet so you can explain to the employee when the error occurred. Also, to double check OPM's work. We may have identified a FERCCA error, or thought we identified a FERCCA error, and in fact it was not. So, that will then, you'll have proof to show to us that maybe our work was incorrect and that it wasn't a FERCCA error.
Exactly. And additionally, whenever you're double checking this, remember the FERCCA worksheet has the from and to dates. It has the actual lengths of service. One of the things that is not on the service history that's on the FERCCA worksheet is, again, remember, FERCCA errors are only FERCCA errors as of 1/187 or later. So you may have had appointments that straddled that 1/187 line, and you're going to have to see if they had 5 years as of 12/31/86 and so forth. So again, you're going to have to break up appointments before and after 1/187. You're going to have to determine the length of the FERCCA error with a certified summary of service in the IRRs. It's not going to show that. The FERCCA service history worksheet gives you all that information that you need, as well as whether the coverage is correct or not, to help you determine that. It's just reformatting the data in a way which makes it FERCCA friendly.
An individual has been retired for 16 years and now is being corrected from CSRS to Offset. Will the agency be responsible for the shortfall of CSRS funds that will need to be transferred to Social Security?
Yes. Again, if you look through BAL 05103, that gives you for every scenario. Okay, whatever the combination of errors is, if they're SIRS, should be FERS, and they elect SIRS, whatever the election is, that BAL will walk you through both the HR responsibilities and the payroll responsibilities, and it goes into detail in the payroll responsibilities as to how to move the money around. So that really gives you the details as far as what has to happen and what the agency is responsible for. Again, remember, you can't bill the employees. Really, the only thing you can bill employees for is for Social Security deductions for the non-barred years, and even in that instance, we suspend collection for 45 days, and the employee can file a claim for out-of-pocket expenses for those deductions, and if they do, we will pay them.
The Senate found a FERCCA error, and there were two previous agencies where the error occurred. Since the House and the Senate do not use SF50s, does a prior agency need to make these actions? Or our IRR will be noted when the person retires?
Okay. For legislative branch employees, particularly House and Senate, there is a provision that you can't share OPFs across the branches of government. So when an agency that's an executive branch agency encounters an error that occurred at the legislative branch agency, essentially what's going to happen is the legislative branch agency is going to send a transcript of service to the executive branch agencies. OPM sees that all the time. I mean, we get for legislative branch service, a lot of times since they don't use 50s, we get what they are essentially is a transcript of service. It's the same information that's on a 50, but it's actually in a memo or letter format, and it shows the from and to dates and everything else. So that's what you're going to use, and you can use that as the official record from the legislative branch because that's what OPM uses for processing.
I have also received FERCCA error letters from executive branch offices when there was not an error. The agency is using the continuity of coverage rule and does not apply to the House or Senate.
Yeah, that's just an educational thing. I mean, you just need to be aware that there are some special rules for legislative branch employees. Again, if you use coverage determination tables, it should mention that there are special rules for legislative branch employees. So you just really need to, if you have a question about that, you might want to reach out to the benefits officer at whatever legislative branch agency you're working with that has the error. For example, if it's the House or the Senate, we have a list of the benefits officers on OPM's website in the benefits officers directory. Again, this is the list that you're going to use even if it's within executive branch agencies. For example, if OPM has a FERCCA error and it occurred at multiple agencies, we may need to reach out to, for example, just because I talked to them before I came up here, Navy, for example, and say, hey, guys, you need to talk to the benefits officer there because there might be a question. So same thing with this. Access the benefits officers directory and work with the benefits officer at the previous agency to clarify any issues.
An agency has a question with one of the retirement coverage determination questions for people who have multiple breaks in service after 12/31/1983. The question asks, did employee have a break in federal service of at least 365 days that ended after 12/31/1983? So their question is, which break in service period should they use to answer the above question? Should they use the last break in service that was right before the appointment that they're trying to determine if a retirement coverage was correctly coded?
That seems to be looking at two different rules. So if there's a break of over 365 days after 12/31/83, that's going to then most likely have that mandatory Social Security coverage. It sounded like the question was, though, referring to the second way of looking at the 5-year test. And that you would look at, and that's a break in service of 4 days or more after 12/31/86. And that you're going to look at the most recent break prior to the appointment you're currently looking at to determine coverage.
Yeah. And it is easy to get those kind of confused sometimes, but yeah, the Social Security, because FERCCA is a process and it's a step-by-step process, you need to stay within those processes, and obviously the 5-year test is after the mandatory Social Security coverage. So just make sure you're aware of which step you're in the whole process.
The next question is, how do request TSP contributions to bill FERCCA compare estimates when an employee is retired and only have last known address? An agency has a couple of old FERCCA dated cases dated 9 to 10 years old, and the employee has retired or separated.
Well, for separated employees, that's going to be difficult because, yeah, we're not even going to have that information. For retired, I mean,
Yeah.
we can give you if it's a FERCA, if we've sent something to you and they're a FERCA error, I mean, we can provide you with the most recent contact information because they're going to have to make an election by law. For TSP may be able, yeah, you might want to.
Updated record, yeah.
Yeah.
Contact info.
Yeah, TSP may have some updated info too. That might be for separated employees as well, because they can still participate in TSP if they're separated. I mean, they're not going to make any additional contributions, but they can still move the money around between funds. They can, withdraw or leave it in or whatever certain things they can do as a separated employee.
Recently, an agency discovered a FERCCA, and the employee has a 6-month opportunity to make an election, FERS or CSRS Offset. Within the 6 months, the employee has now experienced a live event, divorce. The former spouse is entitled to part of the annuity as well as a TSP lump sum. How should we advise or cancel the employee? What if the former spouse contacts TSP now before the employee makes the election? Any guidance is greatly appreciated.
Well, in that scenario, since the former spouse is entitled to part of his annuity, they will have to make an election together
Yeah, that's.
or get her consent.
Yeah, exactly. They're going to have to work together to make this decision. And I know that in some cases this could be a little awkward if you're in the midst of a divorce. But, like anything else, this is part of a property. It's in the same thing that you're dealing with property settlement and everything else. When all these funds are intertwined, I mean, you're going to need the spouse's consent to do anything. So you guys are going to have to work together. At this point, I would say the agency counsels the employee, maybe together. You get, if you need to, you get attorneys, you get financial counselors. I believe that a lot of agencies offer certified financial planners through the EAP program. Some other agencies also have them upon request. It just depends on the agency. But that would be a good way to go as well, to involve somebody who can actually look at this from, a third party but at the end of the day, spousal consent is going to have to happen for anything to make any elections.
The next question is as follows. My scenario is an employee was placed under a CSRS offset under a term appointment in 2010. I know CSRS offset employees are excluded from term appointments. The employee transferred to another agency before the error was fixed and was placed under a permanent appointment and put under CSRS offset at the new agency. The error was found in 2019. Does this constitute a FERCCA or just a mandatory correction? If it's a mandatory correction, with which BAL should be used? Also, what about the TSP contribution for the 7 months that the employee should have been FICA only?
Well, I think that depends on when they got their new appointment at the new agency, because that depends. Since 2010, it was the term appointment, and they should have been FICA only. It depends how long they were in that appointment. If it's 3 years or more, then that would be a FERCA error. If it's less than 3, it would be a mandatory correction.
Yeah, exactly. And then, of course, you're looking at and again, there are instructions for both. If it's a mandatory, if it doesn't fall under FERCA, you just do the administrative, and there are procedures, I believe, for how to move the money around. Again, if it's FERCA relief, there's an advantage there in some ways, usually for moving money between the barred years and the non-barred years. But in this case, it doesn't sound like that's going to be an issue, because it CSRS offset and FICA and Social Security would have been paid either way. So there really shouldn't be much in the way of Social Security, which is going to be different. So.
The next question is the BAL 03-104 does not designate a coverage error period, i.e. more than 3 years or less than 3 years for the 5 categories that do not provide an election and that must be corrected. In each detailed section in the vow that relates to the corrections, the instructions in the vow state that the remark, quote, correction due to Public Law 106-265 FERCCA, unquote, is to be included. Would it be correct to have this remark on correction cases that are before 12/31/86?
No. FERCCA only applies as a 1/187 or later. So you cannot put the remark on a 50 or anything else before 1/187. FERCCA only applies from 1/187 forward. The reason for that is because FERS didn't exist until 1/187. Everything prior to that is not FERCCA. I mean, you may have an error in coverage, but it's not going to be subject to FERCCA, so you cannot put that remark for anything that occurred. FERCCA only applies from 1/187 forward.
I discovered a FERCCA case for an employee last year. I send the employee a certified letter and have not heard from the employee to date. What steps should I follow now?
What were the timeframes again? Sorry.
The error was discovered last year, and the certified letter was sent immediately after, but they've not heard from the employee to date.
You may want to try and reach out to them again. Of course, there are the options in the BAL 05103 on default elections. So it will list, depending on what system they belong in, what the default election should be. So really, you want to give them, I would give them another chance to try and make that election. If you still hear nothing, then you're going to have to make a default election.
Yeah, and those are all listed as in the BAL as well. It gives you, for example, what the coverage error is and what the default election is going to be. So all that information is right there. So when you do the default election, then you're going to refer, once you know what system you're putting them in, or you're defaulting them into, you go to BAL 05103, and that tells you everything that HR and payroll needs to do as far as moving the money around.
If you cannot obtain the records to review a possible FERCCA, how do you proceed? The scenario is that the employee separated 3 years ago and is requesting a refund of contributions. OPM identified a possible FERCCA, and PRC states they do not have the file.
Well, that's a problem. I mean, if NPRC doesn't have the file, we need to find, unfortunately, this is not uncommon. I mean, we have seen that before where they can't locate an OPF. I mean, we eventually need the OPF or those documents need to be recreated. The problem with that is, I mean, you know, you may be missing some service, so it's going to be contingent upon the employee to provide as much information as they can as well. Hopefully, they've got some information on hand. For example, old 50s, leave and earning statements, anything that we can use to reconstruct the record. But I would reach out to the last employing agency.
Check with OPM as well. Maybe we requested and we have the OPF.
Yeah, that
it's
could
worth
happen.
A shot to see if we have it as well.
You might want to double check with NPRC again because maybe it was in transit. Again, now we're just playing detective here, essentially. We're trying to find something that's missing. And if, say, for example, it was destroyed or lost, which is rare, but, you know, it does happen. I mean, there were a lot of OPFs that were lost in a fire before, and floods and tornadoes and assorted other natural disasters. In that case, again, you're going to have to compile stuff from whatever is available. Any payroll records from previous agencies, if they have those archived or microfished, you might be able to access that. So if we know where the person worked before, we might be able to get that information. Again, reaching out to the employee, leave and earning statements, SF50s that they have copies of, anything that you can use.
I have a possible FERCCA case and I'm still learning the process. Is there someone that I can reach out to that could help me and guide me through the process? Is there a POC?
Generally, if you're not the benefits officer, you're going to talk to your headquarters depending on the chain of command at your agency, you may want to reach out to your headquarters benefits officer to get guidance there. And if it's not clear or they need guidance, they will then reach out to their liaison at OPM.
Yeah, and we'll be glad to help you.
This question is a follow-up to a previous question. Who fixes the SF50s if the agency who discovers the error does not use SF50s?
Well,
You would use, I guess it depends what documentation you use, but you would use that documentation.
yeah, I mean, I'm thinking, because I know Postal Service doesn't use 50s, they've got their own version, so they would fix theirs, the equivalent of a 50, whatever the equivalent of the 50 is, that the current agency would do that, and then if it spanned multiple agencies, the previous agencies would have to correct theirs. That's one of the oddball ones where, for example, normally the HR office would correct the 50s for the entire period, but if you're straddling something like a legislative branch, the legislative branch can correct the transcript of service for their part, but at that point it is going to fall on the prior agency who uses the 50s to correct those, because obviously the legislative branch couldn't correct 50s because they don't use them. So that's the one exception to this whole thing where we say the current agency has to fix all the 50s. Clearly, if they don't use 50s, they can't fix them. So you're going to have to work with the prior agencies.
Will OPM bring back the coverage determination application at some point to help with FERCCA determinations?
I don't think so. I doubt it. I mean, the FERCCA coverage determination application was very limited. It only did the basic coverage determinations. I can't speak to what future technology is in development. Do you have any ideas? I
No.
don't know of anything that we're working on right now.
Not that I'm aware of.
Yeah. I know some of you as agencies use different software. I don't know if that actually does some coverage determinations for you or not. But again, we offer FERCCA classes, and we're more than happy to teach you. Day one is essentially 5/6 of the FERCCA process for making FERCCA eligibility determinations is coverage. And again, Chapter 10 in the CSRS and FERS Handbook has been recently updated. So all the information you need, I know it's not as quick as necessarily plugging data into a software program and having it put out an answer, but you do have all the resources available to you to make those coverage determinations.
Is there a continuity of coverage more than 20 years for an active or separated employee? Are corrected SF50s required or just an amended IRR?
Can you repeat the question? I don't
I
understand that.
Is there, if there's a continuity of coverage more than 20 years for an active or separated employee, are corrected SF50s required or just an amended IRR?
I still don't quite understand. I don't understand the question, because continuity of okay, so essentially continuity of coverage is if you have a break in service of 3 days or less, you retain your prior coverage. So I don't quite understand the 20 years here, because essentially what it is how we define a discrete period of service. By law, we describe a discrete period of service as a period of service that is separated by a break of more than 3 days. Breaks of 3 days or less, it's like one continuous period of service. Even if, like, say, for example, I work at OPM and then I move to Interior 3 days later, it's a transfer. And in fact, when making a coverage determination, you would use a transfer and conversion table on that, because there's no real break in service. We consider it to be one continuous period of service. If I had a break of 4 days or more, then it would be a discrete period of service, which is also would allow me to make a FERS election at that point. That's why the FERS election opportunities occur if you have a break of more than 3 days, because at the time you exceed more than 3 days, you are essentially looking at discrete periods of service, okay? So If you're listening, please, if you can clarify the question, we'd be more than happy to answer it. I'm just not quite sure we understand where you're going with this.
Has OPM uploaded the FERCCA packages to the retirement data viewer?
Not that I'm aware of. I've not come across that. That's not to say that we might not have put any of those up there, but
Yeah, I haven't seen them imaged, but I haven't been in that application in a while because we're not really in processing, so a lot of times we don't really see the IRRs a lot of times unless there's something specific with a case. Yeah, I'm not aware. I really don't know. We would have to get back to you on that.
Can you outline the process for handling a FERCCA?
Sure. Do you want to go?
I mean, I guess generally you're going to want to start with BAL 04 108. That kind of it's a step-by-step process, a six-step process
Yeah.
to determining if a FERCCA has occurred. So you're going to fill out that FERCCA service history worksheet. You're going to break up any periods that straddle that 12/36/81/11/87 date. Then from there, you're going to go through and determine if any of the appointments are excluded from CSRS. You're going to want to then look at the Social Security determination to see if mandatory Social Security coverage exists. Then you'll look at FERS exclusions. And again, from that point on, then you'll be able to use the determination table. So that's when you'll then use the 5-year test. There's also, depending on if it's a rehire, transfer conversion, or a new hire, you could use those determination tables as well, which can be found all in Chapter 10 of the CSRS and FERS Handbook. And from there, you would then use the FERCCA determination table. It's a separate table to determine if if the individual is eligible for FERCCA relief.
Yeah, and that's essentially the process. Remember, it is a 6-step process, and 5/6 of it is coverage. The very last part is determining if the employee is eligible for FERCCA. One thing I would suggest is if you think you have a FERCCA, you need to review coverage determinations for every period of service that the employee has. Okay, not just the last one. Because many times we find errors in prior periods of service that occurred at other agencies. In fact, that's one of the common ways that we identify FERCCAs is another agency made a coverage error, the person left that agency wasn't aware that they made a coverage error, and when they get hired at the new agency, they suddenly find that the prior agency had them in the wrong retirement system.
And to add, so once you do that, then the next step you would look at BAL 05-103, because that's going to show you, depending on what retirement system they were in, which one they belong in, well, if they have a choice, and if they have a choice, their options. And then it gives you a step-by-step guide on HR functions, payroll functions to do based on the election they make.
Yeah, so that's it in a nutshell. And then, of course, as we heard in one of the prior questions, if somebody doesn't respond, you're going to want to normally they have a 6-month period of time before we default them. However, we understand that this is a difficult decision. I mean, in some cases, you're looking at the comparison between, okay, am I going to get more money in the basic annuity, or, if I'm in FERS erroneously, what do my TSP returns look like? How much matching contributions have I had? What are the earnings on that? What funds did I invest that money in? I mean, all kinds of things can weigh on what your decision is going to be. So so we understand that it's a complicated decision. So we encourage agencies to be generous and say, okay, if they've come up on the 6 months, if they reach back out to you and say, hey, I need more time, I'm really trying to figure this out. I mean, within reason, give them time to make the decision. If they need to still talk with financial planner, if they're still trying to work things out, and of course, depending on where they are in their career too. If somebody's getting ready to walk out the door and retire, their need may be different than somebody who's going to be on the rolls for another 10 years or whatever. But at the end of the day, if they don't make that determination within a reasonable amount of time, then you're just going to have to default them.
We had a former employee that was erroneously placed in CSRS, but she should have been placed in CSRS Offset when she was employed with another agency from November 1985 to March 1986, less than 6 months. The agency has corrected the personnel records for that period. Is correcting the IRR the next step that the agency must take to correct the record, or are there other actions that must be taken?
Well, that is prior to 1187, so that's not even a FERCCA. That is just an administrative correction. So you just follow your administrative correction processes. Essentially, for that, you're doing a -1, whether it's a 2806-1 or a 3100-1. You're essentially, in this case, it would be a 2806-1 because it's prior to 1187 and FERS didn't exist, so you're not even going to have a 3100. So disregard that. I had to go back in time to figure out where we were here. So yeah, you're going to do the corrected one. Now, of course, at this point, Social Security is not going to really, you're in the barred years, and so there's not going to be a lot of adjustments that you can make with that, but you are going to have to correct the payroll card. Payroll will have to do that.
I have a question regarding correcting all of the SF50s. About 06-106, the Federal Erroneous Retirement Coverage Corrections to Standard Form 50s, shows that in most cases, only the original erroneous SF50 should be corrected, as well as the most recent SF50. It does not mention corrections for the interim SF50s. Is it a requirement to correct all of the SF50s or only the original erroneous SF50 and the most recent SF50 with the FERCCA remarks on both as described on BAL 16-106?
Well, you want to take or no? It's weird, and I'm not saying this because essentially because it really depends on how your payroll office is going to deal with this too. In some cases, we have agencies, for example, we see the 50s done a couple different ways. Some agencies will do 150, and on that 50, when they're making a correction under FERCCA, they'll put, this 50 corrects this, changes this coverage from, say, CSRS to FERS, and it cites the public law and says that this error is due to FERCCA. It also, they can put a remark that says this corrects all previous 50s retroactive to the date that the error occurred. So some agencies can do that on 150. Some agencies have to do it on 250s because of the way their systems are programmed. So you may see one where they have 150 that shows that this changes the coverage from this coverage to this coverage, and it's due to public law, FERCCA, that remark that goes on there. And then they have to do a separate 50 that says this corrects all prior coverages retroactive to whatever date the error occurred. Some agencies I know have to do 50s for every action because their systems have not been programmed to handle that. So as much as I would like to give you a one answer fits all, it's really going to depend on how your systems, on what your systems can handle and how they're programmed currently.
How many people staff OPM's Furka section?
We don't even have a Furka section anymore. That was we had one at one point, and I think there were at its height, there were a number of people working because initially we were getting Furkas from everybody, and we were finding them too because the legislation was new. That was in 2004. I mean, we even had contractors working with us and stuff. As that dropped off, we had a Furka team for a period of time, and that ended up dwindling down to 3 or 4 people, and now it's been delegated to the claims branches, so they do that on their own. So there is no official FERCCA team anymore. We've got the legal administrative specialist that process the case that will identify a FERCCA and then remand it back to the agency. We have us in benefits officers training and development, or benefits officers development and outreach, sorry, we changed our acronym, to assist you as liaisons, but Yeah, that's really about it.
Yeah,
There's not really a FERCCA team anymore, so, that deals with the individual legal administrative specialist that's processing the case.
Can you please state which chapters of the CSRS Handbook were updated?
Well,
Chapter 10,
10,
Chapter 100.
100. There are probably other chapters that were updated. I can't think of them off the top of my head. I know we've had several that were I know 10 is a big one because that one was coverage and we really needed to incorporate FERS Ray and FERS Fray. Reemployed annuitants, there were massive changes to that because one of the things we had to take into consideration was credit for unused sick leave for reemployed annuitants. There were issues surrounding that. I'm trying to think of other ones that we've updated recently. It was one of the earlier chapters, like 1 or 2.
There's a couple more, and it should say, when you look on the website, next to the handbook chapter, it should state on the side when it was last updated.
Yes, and there's a new format as well. If you're in a chapter and you're not seeing to the left-hand side all the individual breakouts, if you're seeing it more like a Word document, that's the new chapters. So those are the ones that have been updated. Also, the updated chapters all have hyperlinks to law and regulation in different forms. So you don't have to actually leave the handbook and go someplace else. You've just got hyperlinks that you can click on. I know it sounds like it should be an easy question, but we've got multiple chapters and multiple stages of development, some that have been approved already and are updated, some that are in the approval process, some that we're working on, some that are in the initial review process. So honestly, we've got them in all stages of development at this point.
Can you please repeat all the vows mentioned associated with FERCCA?
Yes. So it's BAL 04108. That's making eligibility determinations under the FERCCA. BAL 02103. That's correcting erroneous FERS coverage that's less than 3 years. BAL 03104. Retirement coverage error corrections. That's errors that do not provide an election. And then BAL 05103. Retirement coverage error corrections. And again, that's a step-by-step guide for correcting errors.
In FERCCA training 2 years ago, we were instructed that OPM would run the TSP portion for someone incorrectly in CSRS. That should be in FERS. I tried reaching out to the listed contacts, but was told by one that OPM no longer takes care of this. Where would I get this information?
I believe in the BAL there is a form that you actually can send to TSP, and TSP does give you some information, so that would be where you would probably need to go. I know at one point we were doing those TSP estimates, but I believe you have to go through TSP now to get all that information.
Where can we send a request for an IRR for a Furka case so that the request will be expedited?
I think generally it just goes to the general fax,
Yeah.
the fax back number.
Yeah, unless you have access to the data viewer and if that document is imaged. If you have not been in the data viewer and you don't have access to the data viewer, someone in your agency should have access to that. And we have designated super users for agencies. So there's somebody in your agency that does have access to the data viewer, and there's somebody who can actually, based on their determination and your position as to whether or not they will grant you access.
Just to add, it's majority of the executive agency. I know there's a few issues with legislative and judicial that they can't get access to the data viewer,
Yeah.
but if it's an executive agency, someone at a headquarters level should have access to the data viewer.
Yeah, so for the first step would be to reach out to your benefits officer and see if you have access to the data viewer, if there's somebody who does. And that is probably going to be the quickest way to do it, because if either you can find the person or they can get you access right away, then the documents are imaged, you can see them right away. Otherwise, you are going to have to do the fax back, and that could take a couple weeks.
or longer.
Or longer, yeah, depending on the demand. Because remember, OPM deals with millions of retirees, and so and we're getting them from all agencies. So essentially, what happens when that comes through is that if the documents aren't imaged, somebody actually has to go through the files and find those payroll cards and then scan them and send them to you. So it can take a while.
Once we send the employee a notice that they are a FERCCA case, i.e. with the option to elect between CSRS Offset and FERS, and request that they provide statements from the Social Security Administration and TSP in order to prepare a comparison estimate, when does the 6 months election period begin? Does it begin when the date of the initial notice or the date when the employee provides the requested documents?
It's the date of the notice.
Yeah,
I
it's the
believe.
date of the notice. But again, remember, we said you can be really generous with the time frame. So we're not really, I mean, if you're talking about, it's a week or 2 weeks and, they've got a 6-month election opportunity. I think in all fairness, and probably for everyone, it would be, grant those employees the additional
Yeah.
time that they need. Particularly if it's something where you need information as well. That's something you're going to have to work with the employee. Again, you don't need to be super rigid with these time frames. Obviously, you're aware as well because you need this information that the employee has to take time to get it to you. So, again, you're working with the employee, that's fantastic because, again, you can extend the time frame if you need to.
I assume that we continue to send FERCCA updates and discoveries to OPM at The Rock and attention CIB-FERCCA. What happens once OPM receives that information?
Well, they're filed. We keep track of all the FERCCA cases because there could be instances, in fact, we're required to do this because Congress may actually want that information. So in most cases, we're filing that away. We're keeping track of those, and we do have that information available. So if anybody needs to know how many FERCCAs we have, if there are how many FERCCAs an agency has, if they've reported them to us, we can provide that information to the requester. That is a little outside of our area as far as that goes. I'm not sure what the specific process is. If, say, for example, a committee wanted to know how many FERCCA errors DOD had. We could provide that information based on the fact that we have all that. But essentially that's why. It goes into a file and it's used for management and informational purposes.
Are the updated chapters in the handbook out there now with a current revision date? I only see July 17th for Chapter 10 and October 13 for Chapter 100.
Yeah, those would have been.
Those are the updated. I know there's a couple more. I just can't think of them off the top of my head.
Yeah, I know there are some others that we've updated as well. I know the coverage chapter, as you said, has been recently updated within the last few years, and Chapter 100 is a little bit older, but nothing has really changed. We have had the last major legislation we had that changed reemployed annuitants was the NDAA that affected FERS refunds, for sick leave. It changed the date for actuarial reductions under CSRS from 10/190 to 3/191. It also provided a delegated dual comp waiver authority for agencies but under limited circumstances that got extended actually until 2019, but that really didn't, and that kind of affected reemployed annuitants, and that was actually even mentioned in the chapter. But that was actually the last big legislation that affected reemployed annuitants. If there is additional legislation that changes reemployed annuitants, we will go back and modify that chapter and give it another update. But We only update chapters when something changes that requires an update to the chapter.
What if we have a FERCCA case assigned to us from OPM for an employee that's separated from our agency over 10 years ago, and we have no idea of how to contact the employee or if the employee is still alive? How do we close this case?
I would reach out, back out to the point of contact that contacted you from OPM to see if we have an updated address that you can reach out to, for starters. And then I guess it would depend if the former employee is no longer alive, if there's a spouse that may be able to make an election, we're going to have to look into that as well.
Or children, survivors of some kind. But the reason that you're getting it is because there's no limit on when, there's no time limit for FERCCAs. If it's a FERCCA error, it's a FERCCA error. It needs to be corrected at some point. So if you've got a FERCCA error, I mean, there is no time limit. So once it's identified, you know, we send it back to the last agency that had the employee, because they're going to be the ones that are going to be responsible for correcting it.
A follow-up question to that is, it also appears that FERCCA corrections were done 15 or 20 years ago, but I cannot find a FERCCA letter or election for this case. Do we have to go through and fill in the blanks now that we're not completed the FERCCA, now that we have to complete the FERCCA case?
In that instance, I would reach back out to OPM. That would be an instance of where you filed everything with OPM, where we might actually be able to find out what happened before, and we might be able to access that data depending on what's in the file. If you're talking about that long ago, that was still in the beginning stages of FERCCA, so I'm not sure. Hopefully it was all done correctly, and I'm assuming that, you know,
We should still have that documentation.
we should still have the documentation. It's just, what is that documentation going to be? Hopefully it's complete. I believe that it probably would be, because at that time, since it was in the beginning, we were really reaching out to agencies, and they were very careful about including, in some cases, more information than we needed. But that should be in the FERCCA file, so you might want to reach back out to OPM and say, hey, can you look in the FERCCA file? Can you send us the information that you have on this from the last FERCCA correction?
If one doesn't notice that an employee has been placed in the wrong retirement system until the employee is about to retire, and you do not have enough time to complete a FERCCA prior to retirement, then what is the procedure?
Well, then I guess if the case has already come to OPM, we would process the case in the wrong retirement system, notify the agency of the FERCCA and to correct the FERCCA, and then at that point, once we get all the information, we would then correct the retirement to the correct retirement system.
Exactly, and that brings up some real issues, though. I mean, as an agency, when you're counseling employees in that situation, you need to be really careful, particularly if you're, and this is all in the FERCCA, the HR checklist and everything else, you know, your counseling points that you provide with the decision package. But remember, CSRS and FERS have completely different rules. So, for example, one of the big things that I can see right off the bat in a situation like that is CSRS, you can retire at 55 with 30 years of service. If you are FERS, we have a minimum retirement age that's anywhere from 55 to 57. So you could have had somebody that retired under CSRS or CSRS Offset at 55, that if they elect FERS, for example, if that was the error, at the time that they separated, they may not have been eligible to retire. So now you've got a situation, and that's going to have to be explained to the employee. I mean, there are things that are going to need to be worked out where, you know, somebody, particularly if you're finding it now, like just as they're retiring, you know, we may be able to pay them some annuity up front based on the wrong retirement system, but then if they're not eligible, then you're going to have to take them back, potentially give them back pay, correct all that stuff. They're going to have to pay back annuity, or actually will withhold the annuity from back pay, and so forth. So there are there are issues with that. I mean, and it's going to depend on the situation and what the error is and everything, but just be aware that in a situation like that, counseling is going to be paramount.
I'm in a very small agency and my HRO does not have access to the data viewer. They've never heard of it. Is there anyone I can speak to at OPM to get access to the data viewer?
Yes, yeah, that would be through our office. So I guess we will save your email. I got to look and see. I don't remember who the point of contact for the data viewer is
Yeah,
anymore.
I'm not sure. I
So-
thought it was Johnny, but I'm not sure.
Yeah, I'm not sure anymore either. So
It is.
we'll forward your email to the point of contact, and they'll look to start the process to get your agency set up.
An employee made a FERCCA election from FERS to CSRS Offset. She pulled the rest of her TSP out of her account when she was notified of the FERCCA. She said she spoke to TSP and was told that she will not have to pay back the 1% agency contribution or agency matching. From what I've read, she will have to pay it back, and I have contacted payroll to obtain the TSP information that she would be responsible for. Can you tell me if she will actually be responsible for paying back the 1% agency contribution and matching? Could there be any reason why TSP would tell her that she would not have to pay it back?
Without the details of the situation, I mean, I can't say for sure, but in most cases, they do need to pay that back. Particularly in a case like this where it sounds like, they knew and just did it. Yeah, unless there's some exception, unless there's something else going on, and it very well could be. I mean, we don't,
Yeah.
Again, as you've seen, sometimes coverage determinations hinge on one day. And so in a general question like this, that's something that, there might be another piece that we're missing, that TSP said that or gave that person that advice, or they could have talked to somebody who didn't know. I mean, it could be anything. I wish I could give you a...
I would check with TSP as well. I would contact
Yeah.
TSP to see just even their general response.
Yeah, but my understanding is that they would have to pay that back.
If we find a retirement coverage error that spans multiple agency, whether it's FERCCA or administrative, can we send the payroll corrections to the prior agency/payroll office to complete? Or should we be asking the current payroll office to correct all IRRs, retirement contributions, etc. for prior agencies?
I don't quite understand. I mean, can you read the question one more time?
If we find a retirement coverage error that spans multiple agencies, whether it's FERCCA or administrative, can we send the payroll corrections to the prior agency or payroll office to complete? Or should we be asking the current payroll office to correct all IRRs, retirement contributions, etc. for prior agencies?
Well,
I think we kind of covered it. But no,
Yeah.
that would be, HR would correct the personnel records, but then you'd have to notify the prior agency's payroll to correct those records.
Yeah.
And adjust Social Security.
yeah, because the current agency payroll office normally can't correct another agency's payroll. Now, because we've moved to shared service centers, I guess conceivably you could have two agencies serviced by the same shared service center, in which case they would essentially be taking from this and walking it over to like another part of the shared service center that maybe, or another employee, maybe it's somebody who sits right beside them that handles the other ones, and say, hey, I've got one for you. I'll fix my part, you fix your part. But generally speaking, if there are different agencies and different payroll providers, each payroll office is going to have to correct the 50s for that, or not the 50s, I'm sorry, the payroll cards for that payroll office. The HR office can only do the 50s.
If we have a FERCCA case and we are informed through the process that the employee is deceased, and so it's his or her spouse, but has 3 children, do we submit the FERCCA notification to the known address?
Well, I'm thinking that it's going to go to the spouse first, but it's going to be contingent upon whether there was a survivor benefit as well. I mean, again, this is kind of a hard one to answer. In most cases, I would say, just without knowing, I would say the spouse would be the person you would notify first, because unless you get your spouse's consent to something less than a full survivor benefit, the spouse is going to have a survivor benefit. And so in most cases, the FERCCA is going to affect that. If it's children, they're provided by law. So I'm not sure. I would start with the spouse and find out what the benefit is. It's hard to say. But that's what I would do first, because again, that spouse would have to have consented originally to not have a survivor benefit. So if they died in service, then obviously the spouse is the one you're going to reach out to.
And with that, it looks like we have no more questions.
So yeah, thank you. We will, for those of you who are on the listserv, just be aware whenever we do offer FERCCA trainings, we will put that out on the listserv. Whatever city we happen to be in, whether it's here in DC or somewhere else. And if you want updated FERCCA training, or if you've never had FERCCA training, we encourage you to sign up for it. Those classes do fill up fast, so whenever you do see the announcement on the listserv, you might want to act quickly. And thanks for listening today.
Thanks.